The Oversight Subcommittee on Weaponization of State Government will come to order. Will the clerk please call the roll for today's attendance?
Chair Regas.
Here.
Representative Shriver.
Present.
Wolford. Kohetsky. Here. Wagala. Madam Chair, you do have a quorum.
Thank you. Representative Shriver moves to adopt the minutes from the June 25th meeting. Hearing no objection, the minutes are adopted. Good morning. Today we're taking testimony on the alternate electors case from the 2020 election. Michigan's Attorney General Dana Nessel prosecuted 15 defendants for signing a piece of paper. I'd like to welcome Kevin Kajewski up to testify. Kevin was one of the attorneys for alternate electors in the case. After your presentation, Kevin, then we'll have questions from the committee, and then after your presentation's done, then we'll welcome up Attorney Nick Somberg, who was also an attorney for some of those electors, and then he will be able to take questions as well. So whenever you're ready, Kevin.
Thank you very much, Madam Chair. And thank you. I'll just start over now since I'm on the record. Thank you, Madam Chair and members of the Michigan House Oversight Subcommittee on Weaponization for inviting me to testify today. My name is Kevin Kiewski. I'm an attorney that's practicing here in Michigan. I'm also a candidate for Michigan Attorney General for the Republican Party. However, I am only here today in my capacity as an attorney for Clifford Frost, one of the 16 individuals that was wrongfully charged by the Attorney General in connection with their actions as alternate electors in the 2020 presidential election. On September 9th, 2025, and many people know this, the district court judge, Kristen Simmons, delivered a decisive victory for justice by dismissing all charges against my client and the others, finding insufficient probable cause to bind them over for trial. This ruling not only vindicated my client, Mr. Frost, but exposed a troubling pattern of political weaponization in our state judicial system. I appreciate the opportunity to address three key areas you wanted me to talk about today. Number one, the facts of this particular case. Number two, why specifically it was thrown out of court. And third, the evident lawfare orchestrated by Attorney General Dana Nessel. My testimony today will draw upon the court records, including our successful brief seeking dismissal, as well as public statements and actions by the Attorney General that reveal the true partisan motivations behind this prosecution. I'm going to aim to keep this opening statement comprehensive, providing the detail that the committee needs, and certainly at the end I will welcome the committee's questions. First, let's begin with the facts of this particular case. In the aftermath of the 2020 presidential election, Michigan, like several other states, was embroiled in significant disputes over the vote count and certification process. Allegations of irregularities, including issues with absentee ballots, voting machines, and procedural violations, led to lots of lawsuits and legislative inquiries. Amid this uncertainty, on December 14th, 2020, the date that's actually set by federal law for electors to meet, 16 Republican electors that were elected by the Michigan Republican Party pursuant to state statute, including my client Clifford Frost, gathered at the Michigan Republican Party headquarters. They signed the document styled as a certificate of vote, casting electoral votes for Donald Trump and Mike Pence. This document, however, was clearly a contingent certificate intended to preserve a legal pathway should ongoing court challenges or legislative actions overturn the certified results in Trump's favor. This was not some type of hidden or clandestine plot hatched in the shadows. It was a transparent precautionary measure rooted in historical precedent. For example, in 1960, Hawaii presidential election contest between John F. Kennedy and Richard Nixon, as we all remember from our history books, that was an issue because the Democratic electors signed contingent certificates while the results were under challenge. And those certificates were ultimately accepted by Congress after a recount favored Kennedy. And again, here in Michigan in 2020, the alternate electors acted with the belief that their actions were lawful, protected by the First Amendment's petition clause to seek redress of grievances, and the constitutional framework for resolving election disputes. No one was deceived, and no fraud was committed. Despite this, in July 2023, nearly 3 years after the events, the Attorney General of the state of Michigan announced felony charges against all 16 individuals, including Mr. Frost. Each faced 8 counts, 1 count of conspiracy to commit forgery, 2 counts of forgery, 2 counts of uttering and publishing, 1 count of conspiracy to commit election law forgery, and 2 counts of election law forgery. These are very, very serious charges, and they each essentially carry potential prison terms, and some of them for up to 14 years, potentially. The prosecution alleged that the alternate electors had forged public records with the intent to defraud, claiming they falsely represented themselves as the duly elected electors when they knew the official results favored Joe Biden. However, ladies and gentlemen of the committee, the facts tell us a different story. The alternate electors never claimed to be the official slate. Their certificates were conditional, as I will detail in just a few moments with my testimony, a standard practice in any type of contested election. More so, the delay in bringing the charges after federal authorities and other prosecutors had reviewed similar type of allegations here, but declined to act, raised immediate red flags about the timing and the motivation. This was not a pursuit of justice. It was a calculated political strike. The prosecution's own affidavit from their special agent that was the officer in charge focused almost entirely on the Republican elector certificate, admitting that it was signed by the 16 Republicans and mailed to federal archives, but conceding that Congress only counted the votes from the certified Democrat electors. Now, turning to why this case was thrown out of court on September 9th, 2025. After a thorough preliminary examination in the 54A District Court here in Lansing. And again, we actually had all 16 of these individuals that had preliminary examinations, 3 different cohorts. I actually had to be here for a full week. I've never had a preliminary examination last a full week, nor the challenges logistically of fitting so many different attorneys and so many different co-defendants in the same room. But Judge Simmons on September 9th said that there was insufficient probable cause to bind over Mr. Frost and, by extension, the others that were being charged for trial. Our brief seeking dismissal, which the committee has, and as well I know that it's on the screen right now, and I filed this on behalf of Mr. Frost, argued key points that the court found persuasive, drawing directly from Michigan and federal law to demonstrate that no crime had been committed as frankly, a matter of law, in addition to the facts that the court analyzed. And in fact, I remember when I was sitting right directly across from Judge Simmons, and she was giving her oral ruling, I had a brother counsel sitting right next to me, and he leaned over and he said, "Sounds like she's reading from your brief." And so that's why I want this particular committee to have a copy of it. So let's get into this. First, there was a complete absence of any evidence showing intent to defraud, required really by the elements of the crime under Michigan law, and specifically MCL 750.248, defines forgery as making a false document with the intent to injure or defraud. The prosecution failed to demonstrate that the alternate electors intended to deceive anyone. Their actions were public, documented, and contingent on legal outcomes. And in fact, when you take a look at Judge Simmons, when she was actually saying, "I have no idea who commits a crime of forgery or fraud," and then holds a press conference after, I could not agree more. And in fact, we actually had a little bit of laughter in the courtroom from all parties involved when that was said. Witnesses, including those from the Attorney General's own office, testified that the certificates were not submitted as official documents, but as placeholders. The judge noted that the signers really believed, they genuinely believed, that they were preserving a constitutional remedy, not trying to go ahead and perpetrate a scam. As outlined in our brief that the committee has, the forgery required the false making of a document in a way that exposes another to loss or creates a liability. Here, the Republican elector certificate was exactly what it purported to be: a genuine document signed by these particular Republican nominees to actually be the electors here, expressing their votes as a political protest. It did not forge signatures, nor did it mimic the governor's certification in a deceptive manner. If you take a look actually at some of the exhibits that are contained within my brief seeking dismissal, you will see that when it comes to the governor's certificate, we have one copy, and that was the actual copy that was done by the governor when submitting the Democratic votes, meaning that when it came to Mr. Frost and the other electors, they didn't have a certificate. They didn't make a certificate. They didn't forge a certificate. They didn't do anything that was legally required in order for these votes to possibly be counted, and as I will explain further on. Second, the case ignored historical and legal precedents, as well as the explicit framework of Michigan election statutes. So I will spare the committee the nerd talk and the drama, but just to go through a few highlights. Under MCL 168.42, political parties, both Republican and Democrat, elect presidential elector candidates at their conventions. These folks were actually elected by the state GOP. MCL 168.45 clarifies that voters cast ballots for party slates of electors, not directly for candidates. MCL 168.46 requires the governor to certify the winning slate based on the Board of State Canvassers' determination. And here's the thing, crucially, MCL 168.47 mandates that only certified electors convene and vote, with any vacancies filled from the certified slate. In this case, Governor Whitmer's certification that the Democrat electors actually were able to vote, that was issued on or about November 23rd, 2020, and it also affixed the seal of the state of Michigan to it. What did that do? It made their votes the only legally valid ones pursuant to what? Michigan law. The Republican certificate lacked this certification, and according to Michigan law, could never, ever be counted. This is reinforced actually by federal law under the Electoral Count Act, 3 U.S.C. Section 5. It deems a state certification, quote-unquote, conclusive if made under pre-existing laws at least 6 days before the electors meet, binding Congress in the count. 3 U.S.C. 6 further requires that the governor to transmit certified electors' credentials under seal, and 3 U.S.C. 15 dictates that in this particular case, or in any case for competing submissions, Congress must count only those from electors certified under Section 5 of this particular act, or, if disputed, those certified by the governor. Because Michigan followed its laws precisely as we outlined in our brief over here, the Democrat certification was conclusive. It was. And Congress was legally barred from considering any alternative. As our brief emphasized, the Republican certificate was a legal nullity. It could never expose anyone to loss or create a liability, and it had no potential to alter the electoral outcome. And the congressional record actually reflects this very well. Michigan votes were announced solely as those for Biden and Harris without any mention of the Republican submission. And I think it's also very important to note here for the committee, even though it's not within my written statement, during the preliminary examination, we actually had the general counsel for the U.S. Senate testify. And he actually stated that this was never seen by the Vice President of the United States, nor ever considered. Third, the evidence presented at the preliminary examination was so inadequate. The prosecution relied on hearsay, speculative interpretations of emails, and mischaracterizations of the certificate. For instance, they claim that the documents were quote-unquote forged because they mimicked the official format, but that's precisely how certificates that are contingent are drafted to be valid if needed. You can't do something on a napkin with a crayon. Our brief cited cases like People v. Sulla, a Michigan Supreme Court case that held that forgery requires the writing to purport to be what is not. The writing itself must be a lie. Here, however, the certificate accurately identified the Republican signers and their votes. Any alleged falsehoods were statements of belief, not forgeries. And similar, in addition to that, we have another Michigan case, People v. Thomas, where a police report with a false information contained within it was not a forgery because the document was genuine. So if you actually have a document and there happen to be some particular falsehoods that someone claims, it can't be a forgery unless you actually have something that is really a forgery. But here, the document was real. The judge agreed that probable cause required more than political disagreement. It demanded proof of criminal elements, which simply was not there. MCL 750.249 regarding uttering and publishing, and MCL 168.933A, election forgery, fail as well for the same reasons. There was no intent to defraud via a false instrument capable of legal effect. In our brief, we emphasize that allowing this case to proceed would set a dangerous precedent, turning election disputes into criminal battlegrounds and chilling protected political speech. This dismissal wasn't just a win for Mr. Frost and the other electors. It was a rebuke of government overreach, affirming that the judiciary won't rubber stamp partisan prosecutions. A copy of our successful brief is available, as I have mentioned before, and I'm happy to take questions as it relates to that. But let's get into the third thing I wanted to talk about, the lawfare element, and perhaps the most critical thing to discuss. Let's talk about what Dana Nessel did here. The weaponization of government power for political ends. This case exemplifies how Attorney General Nessel has abused her office to target Republicans, erode public trust in the judicial system, and advance a partisan agenda. And from the outset, her actions betrayed political motivations rather than a commitment to impartial justice. First, let's take a look at the timeline. Federal investigators, including the DOJ, both from the Eastern and the Western District of Michigan, reviewed this particular information, and they declined to prosecute. Nessel herself shopped this case to prosecutors, and including here in Ingham County. By the way, the Ingham County prosecutor declined to charge. And in fact, the Ingham County Prosecutor's Office put forward a memorandum of law, which I do not have for the committee today, but I do have in my possession, that says that they cannot charge. So she's 0 for 3, and then she takes it up herself, apparently. But why does she want to charge it in Ingham County? Well, actually, we have her own words to talk about that. She said during a 2023 virtual event hosted by liberal activists based in California, titled, quote unquote, Defending Democracy, she chose to charge them here in Ingham County, where Lansing is located, of course, because it is a very, very Democratic-leaning county, where she believed she could secure favorable jurors to convict, regardless of the evidence. And in fact, if you take a look at the Attorney General's appearance on CNN shortly after the elector case was dismissed, she actually still maintained this, that I want to go to a jury because they would convict. Well, I find that just very troublesome. If I may, Madam Chair, I'd like to ask that the video exhibit that I provided be played at this time.
This every day. It is the Attorney General of Michigan, Dana Nessel, who charged the fake electors earlier this year. On Monday, she was at an event, a virtual event with some liberal groups, speaking pretty cavalierly about the case. I want to let you listen to it for yourself, so let's play that clip of Attorney General Nessel.
people talk a lot about, oh, why don't you start flipping some of those people so that they can become witnesses against the remaining defendants, the worst acting defendants. The problem is, these are people who have been brainwashed. And when I say brainwashed, how do you flip someone who concedes that they did everything that they're accused of doing, but what they say is, we believe that we were in the right. We think that Donald Trump is the real winner of the election. They legit believe that. They genuinely believe it. So somebody can't even plead guilty if they wanted to, because they can't admit that what they did violated the law because they still think they're right. Ingham County, where Lansing was located, is a very, very Democratic-leaning county. But I worry that there will be people who just won't care that they clearly violated the law because they believe that the ends justify the means, and that, it's okay to do as long as the end game is getting this autocrat into office, who will surely be the end of democracy in this nation.
So, Casey, why does this matter? First of all, this is an ongoing case. You don't often hear the chief law enforcement officer of a state speaking like this about an ongoing matter that her own office is prosecuting. I spoke to some of the defense attorneys representing those fake electors. They think this actually might be a gift to help their defense. Look, if you're so brainwashed, then how could you possibly have the criminal intent that you need to break the law? That's one of the elements of the forgery crime that she has charged that she would need to prove in court. And even outside attorneys who are not involved in this case and support this case, support this prosecution, they think that Nessel may have crossed the line.
We're more vulnerable to domestic and foreign attack.
So what did we just hear? She boasted about pursuing the case after federal and local prosecutors would not, admitting these individuals, quote, genuinely believed they were acting lawfully and couldn't even plead guilty because they saw no wrongdoing, end quote. Well, why the delay until 2023? Well, it's convenient political timing. It coincided with heightened political tensions and Nessel's own re-election efforts, where she attempted to position herself as a crusader against, quote-unquote, election deniers. This wasn't about evidence. It was about messaging to her base. Even more damning are Nessel's own public statements, which we just heard here, and it reveals her bias. She called them brainwashed. She said that they genuinely believed that they won. And how can you flip someone who concedes that they did everything right? Well, I could tell you this. The state top prosecutor here, the Attorney General, publicly admitted that the defendants lacked the requisite criminal intent, or as we would say, mens rea, for the crimes that were charged. Forgery requires knowing intent to defraud. Yet the Attorney General dismissed them as deluded victims of misinformation while still bringing them into court. This is not a prosecution, it's persecution. Her comments were defamatory, inappropriate for an ongoing case, and directly contradicted the elements that she needed to prove before the judge. Her words expressed to liberal activist insiders in the video, it clearly demonstrates the charges were a political calculation and not a pursuit of the truth. The judge's dismissal confirms as much. This lawfare extends beyond my client. Nessel's office has prioritized messaging with progressive groups over the equal application of the law. I find that very, very troubling. She eroded trust by turning the AG's office into a tool for vendettas against political opponents to bolster her own campaign, rather than focusing on real threats like violent crime, human trafficking, or consumer protection. As I stated in my press release following the dismissal, quote, justice prevails against lawfare in Michigan. Today, a Lansing District Court judge dismissed the sham politically motivated charges against Clifford Frost Jr. brought by radical Democrat Michigan Attorney General Dana Nessel, exposing her blatant abuse of power to weaponize the justice system against Republicans for the sake of being Republicans. This vindicates my client, Mr. Frost, and indicts Attorney General Nessel's deranged crusade to silence any dissent, to advance her extreme ideology. The facts here are very troubling, but I also want to mention two other quick things before I conclude that are not reflected in my written statement. This is one of 3 active cases right now regarding the electors. This particular set of criminal charges for Mr. Frost and the others were dismissed. However, in Kent County, there are 3 Democrat electors represented by counsel that are suing civilly all 16 Republican electors. That was filed a long time ago. And they basically say that we have been harmed emotionally, intentional infliction of emotional distress. Well, let me tell you, regarding the particular criminal prosecution, I represented Mr. Frost. In this civil case, I'm also involved in it, and I'm defending 2 people, but now it's only 1. Clifford Frost for this, and also Mr. Haggard, one of the electors who just passed away just hours after hearing he did nothing wrong. He had some pre-existing conditions, he had some heart trouble, and I think it's safe to say, speaking with him and seeing him go through this did take a toll. Ladies and gentlemen, lawfare is real. Financially, on your family, on your time. I'm not saying that it directly killed him, but certainly it took its toll and contributed toward that. The last thing I would mention, and I provided this to the committee as an exhibit, I found this interesting yesterday, and this came out of the Senate Judiciary Committee, where Senator Chuck Grassley was able to share a very interesting thing that was, I guess, declassified regarding a project called Arctic Frost. Arctic Frost was a joint investigation between the FBI, DOJ, the Office of Inspector General, the U.S. Postal Inspection Service, and all these other, 3- and 4-letter named agencies. And it appears that according to the records that were revealed, and I believe if you take a look at his testimony yesterday was Exhibit 5, if you want to take a look at the Senate record, they were tasked in a rather clandestine way, and it just became revealed now, to actually try to go after these false slates. I remember during my defense of Clifford Frost being contacted by Jack Smith's office. And of course, I refused to talk. The thing is, though, it appears that, I'm not saying it is the case, but it certainly appears worthy of investigation to see to what extent, if any, that the Attorney General herself, her office, and her staff participated, cooperated, aided, or abetted in what Senator Chuck Grassley brought out yesterday. But ladies and gentlemen of the committee, in conclusion, this case was never about justice. It was lawfare, plain and simple. The facts show show her awful behavior, but as well, the facts show lawful contingent actions in a disputed election. The dismissal highlights the prosecution's evidentiary failures and legal impossibilities. No forgery where the document is genuine and incapable of causing any type of loss. And Nessel's own words that you just heard here today expose the partisan rot at its core, from admitting lack of intent to venue shopping for Democratic jurors. I'm not campaigning here, but I'm telling you, when I take a look at any prosecutor, you don't look to see who's going to convict your person. If the situation were completely turned around, I would actually represent Democrats. And this is not about me trying to, bolster Republicans and sort of beat down on Democrats. You know what? I think that the Democratic Party, and more so the people of the state of Michigan, deserve more from their Attorney General. Someone that's going to be seeking impartial justice. We must end this weaponization before it further divides our state. And I urge this particular subcommittee to investigate further based upon the testimony that I've provided, the exhibits I have shared, and to really hold accountable those who abuse power, and to further recommend reforms to safeguard against such abuses. Thank you very much for your kind attention, and I welcome your questions.
Thank you. That was very informative. And so, regarding lack of evidence and intent, so Judge Simmons said this is a fraud case and we have to prove intent, and I don't believe there's significant evidence to prove intent. As a defense counsel, did you ever see any document, testimony, or communication that proved your clients intended to deceive anyone?
Absolutely not, Madam Chair. And if I may say as well, when you take a look at the only witness that the Attorney General called, one of the electors that basically had charges dismissed so that he could be free to testify, he was a great prosecution, he was a great prosecution witness for us. Mm-hmm. He was almost a defense witness. He said that, really, I don't know what was going on other than I thought that we were going to be signing something in order to safeguard our rights. Mm-hmm. So they didn't have any indication of any type of intent. And in fact, as we've heard, the Attorney General's own words publicly reveal that.
Was your client ever given a fair chance to present their side before these high-profile charges were filed?
That is incorrect. They never had a chance, really. They were able to perhaps be investigated or speak to investigators at the Attorney General's office. But again, any attorney worth their salt would say that you can't just explain things away, because especially if you have a prosecutor that has an ulterior political motive, it doesn't matter what you say. It could be twisted, it can be contorted, it can be reformatted, and then you can go after someone. So he was never given a fair opportunity to present his side.
How has this prosecution impacted your client's willingness to engage in civic or political activities in the future?
My client, in addition to the others that were charged, they're well into their 70s and their 80s. And in fact, as I've mentioned, one of them passed away, in part because of the actual, I would say, stress that was caused by this particular ordeal. A lot of them, I would say, including my client, they just want to live a very nice, simple, quiet life. Mm-hmm. Cliff is a loving husband. His wife Sharon is a lovely person. They live in Macomb County. Anytime I see him, always gives me a big hug. They just want to go back to their way of life. But I think that they are irreparably damaged. Irreparably. There's not going to be a way to really bring them back to prior to this, where they're going to say, oh, I feel completely safe. They always have to take a look over their shoulder. I mean, people have been debanked. People have had issues when it came to their professional licensure being threatened. That's not the world we should be living in. Mm-hmm. And again, I'm not going to turn this into Charlie Kirk, but this is part of the weaponization that we have that contributes to this dangerous political discourse. I had the opportunity to be on WJR about 2 days ago, and we were talking about Charlie Kirk. And I specifically mentioned not only dangerous rhetoric from people, but as well, when you take a look at that rhetoric, combined with, I'm going to maintain unethical actions like this, that really makes people think that conservatives are dangerous. And I'm not accusing the Democratic Party of doing this. I'm just really taking a look at folks that are on the extreme left end of the spectrum that are putting this forward. I think that many people are normal, and I'm taking a look at both Republicans and Democrats, and they don't want to see things like this. Sure. Because words have consequences, and you can't just light a fire and walk away. And I believe that in some small part, the Attorney General contributed to this political malaise that we have today.
And one final question from me. So, actually two. Is your client in here today with you?
Yes, he is. I'm sorry, did not see him after I came
okay.
down, but this is Mr. Frost in the red shirt right here.
And what is the reason why Mr. Frost is not speaking today?
Because I advised him to. I advised him not to speak for a few different reasons. Number one, when it comes to the Attorney General, she has the opportunity to appeal the district court judge's decision. She has until September 30th, pretty much the end of this month. Not that whatever Mr. Frost would say today possibly could, be added to the record, but I don't need Mr. Frost, respectfully, or any of the other defendants, even though they're not my clients, to speak in order to see what happens next with the Attorney General.
Sure.
That's not right.
So do you believe these charges were deliberately excessive to intimidate or silence?
I think it was to send a message.
And it still apparently is, because we don't have electors today that were willing to sit and be questioned because of the September 30th date.
That's correct.
Still be intimidated by our Attorney General after the case was dismissed.
If I could add one quick thing, Madam Chair, it's not even really just September 30th. I mean, you would have individuals that could perhaps come forward. They can talk about various things, but again, she could bring different charges against them. You know what? Don't give fodder when you don't have to. And I'm sorry to say that, but it's absolutely true, and I don't care what we're looking at regarding this situation or other cases, but here, this Attorney General has been so unpredictable to us, but predictable to the folks that she messages to, because she explicitly has told people her political motivation.
Sure. Thank you. Representative Schreiber.
Thank you, Madam Chair. So the judge, in this case, at the end of the day, said, I believe they, and by they, these innocent Michigan patriots, were executing their constitutional right to seek redress. So they were redressing grievances against our government, and the government assassinated their bank account and their character. I have so many thoughts, but I want to form it into questions. As far as the toll, obviously you can't quantify everything, but in terms of what you can quantify, what was the personal financial toll to your clients during this politically charged persecution?
I can say generally, from what I have heard, some individuals have paid up to $250,000 to $300,000 over the past 2 to 2.5 years in order to mount a defense. I joke around with Mr. Frost when we go around. I'm like, Cliff, do I charge that much? No, absolutely not. But 1 penny or $1 is way, way too much. And you brought up one other thing, if I may speak about this for a moment, Mr. Representative. Redress of grievances. I know that, of course, we have the flat screen TV that we're able to put a particular exhibit or two on. But I remember during the preliminary examination, we had Special Agent Schock on the stand. And you know what I did? I pulled up the First Amendment. I had that there. And we have our 5 essential freedoms. The last one is the right to petition for the redress of grievances. I had Attorney General Schock read that. And then I said, Mr. Schock, Special Agent Schock, you've been a police officer or a uniformed officer for a while. Yes, I think it was in excess of 20 years. And then I asked him, when it comes to that last portion, redress of grievances, what does that mean? And you know what he said? I'm paraphrasing. I don't know. He's the chief investigator for this particular action brought forward by the Attorney General. And I asked him a very simple question about the First Amendment, the petition clause or section of the First Amendment. He had no idea. I like to think he had an idea, but it's troubling that when it came to the petition seeking redress of grievances, he couldn't even articulate that. So if the investigator cannot understand that, how can they possibly do a thorough investigation and possibly even recommend charges.
Insane. Moving to, I guess I should say, building off of this financial toll. I know I've spoken with some of the individuals who were charged. They had issues with employment, being fired from their jobs, not being able to find jobs, not to mention reputational damage and the aforementioned character assassination. Do your clients deserve an apology from Dana Nessel, or even compensation in some way, shape, or form for what they went through?
I'm going to respectfully say this. I think that really, when it comes to Dana Nessel, the Attorney General, she can do as she wishes. That's fine. I think I know what I would do. I think we all know, based upon the facts and the evidence, what you, ladies and gentlemen, would do. But right now, I'm still actually embroiled in litigation against the Attorney General, and that's why I'm respectfully not seeking to comment so much. Mr. Frost actually, and I said in my statement, is involved in 3 different cases. I talked about the criminal case, I talked about the civil case brought by the Democratic electors, but I forgot to mention, and thank you so much for prompting me, there's a 3rd case. He actually sued Dana Nessel, Frost v. Nessel, in federal court, 42 U.S.C. 1983, a violation of his constitutional rights based upon this nonsense. People should not have to go through this in order to actually try to vindicate themselves. Right now, it's currently in front of the United States Supreme Court. We filed a writ for certiorari, which basically is for the non-attorneys, asking them to take up the case. This case, the active Supreme Court case, the 1983 action, perhaps we'll get an opinion, or not an opinion, but a decision from the court whether or not they want to take it, because they get thousands of cases a year. They only take 70 or 80. But I think that this is rather important. And it's actually still a live controversy right now, given that the Attorney General can still appeal. If the Attorney General appeals this particular criminal law decision made by Judge Simmons, well, that U.S. Supreme Court case is still very much active. So I just wanted to add that. Thank you.
I have one final question. Lawfare. This is something that's impacting many Michigan residents, many American citizens. What reforms should the legislature consider to prevent prosecutors like Dana Nessel from using criminal law, I would say for political purposes, but I would say what's going to prevent someone like Dana Nessel using criminal law to persecute our own residents? What can we do as a legislature to stop this from happening once and for all in terms of shaping policy?
I think that really 3 things. First, here in the state of Michigan, I think that when it comes to the very statutes that we have related to actions regarding abuse of process or malicious prosecution need to be changed. And I'm not saying that anyone can go after a prosecutor after a case, certainly not. But if it can be proven, perhaps by clear and convincing evidence, not even beyond a reasonable doubt, but clear and convincing evidence, that's basically like a 70-75% burden of proof, that these were improperly done, politically motivated, then perhaps we don't necessarily have the taxpayer on the hook. Who do you have on the hook? The individual, him or herself. You know, one thing in particular I think is important to note, it's related, not directly, but the Attorney General's office, this is not their first rodeo when it came to actually having problems and paying out for particular sham charges. There was something not that long ago, and I know we have the esteemed Craig Mauger here in the audience, and I think his colleague was able to report on this. But Dana Nessel, her office, was sued civilly because they inappropriately and illegally went after a Detroit police officer with sham charges. The guy is still recovering. And even the $60 to $70 million verdict, I forget exactly what it was rather substantial. I can't quote it exactly. Who's paying that? All of you. I am. Everyone in this room and everyone across the state of Michigan, across all 83 counties. That's not right. And I say this, it's not necessarily because of just Dana Nessel, but I mean, no matter who the future Attorney General would be, Republican, Democrat, or we take a look at any of the 83 prosecutors, they need to know that there are consequences apart from perhaps disciplinary action that could be brought forward by the Attorney Grievance Commission, and then it would go forward to the Attorney Disciplinary Board, or ADB. That's one thing. I think second, there needs to be essentially, and this is more of a leadership issue, from the Attorney General's office, and again, irrespective of who the next Attorney General will be, to actually give some, I don't want to say continuing education, but some guidelines about how this needs to happen, especially when you're going after someone for what can be seen as a politically charged case. For example, I mentioned to you as part of one of my responses that we had the detective not even be able to clearly articulate what the petition for redress of grievances meant. Well, I just want to make sure that there is some emphasis, some training, best practices, whatever you want to say, to ensure that if charges are going to be brought, you do a thorough job. And then the third thing I would say is there needs to be something perhaps, and this is more within the purview of the Michigan Supreme Court through the MCRs, Michigan court rules that would specifically go along or mimic whatever the legislature would like to do in the future in order to protect against lawfare. Lawfare is a bipartisan issue. It shouldn't be done by anyone. And again, hypothetically, if I were elected Attorney General, I'm not going to be going after people because of their political party. I represent my practice both Republicans and Democrats. It shouldn't matter your political ideology. What should matter is justice. Thank you.
Thank you. Representative Wagala.
Hi, thanks for being here today.
My pleasure.
You brought up this idea of dangerous rhetoric. So my question is this: do you think that it's dangerous rhetoric to repeatedly falsely claim that the 2020 election was stolen?
I think that when it comes to the 2020 election, people at the time should have the right in order to seek redress of their grievances. I don't think that if you would take a look at really any sensible Republican out there, they would say that when it comes to the 2020 election, I'm talking about today, that Joe Biden was never elected the president. I even remember going on MSNBC after this particular case was filed, and I said to them, you know what? Joe Biden is legally the president. But if people want to express opinions and not incite violence, then I don't think it is dangerous.
Maybe, thank you. And hopefully you can tell our president that.
That's your first warning. Representative Pohodsky.
Thank you, Madam Chair. In terms of like the overall environment at that time and some of the truly dangerous things that were happening, I think I'm the only one here who was here in 2020. I do just want us to remember that we had committees that had to be escorted out by law enforcement in riot gear because at the conclusion of the committee, people tried to storm the committee rostrum. We also had the Capitol, where people showed up literally, like this is court record, attempting to set the Capitol on fire, planning on setting the Capitol on fire, executing representatives on TV to try and lure out the governor. So I do just want us to remember that I understand what you're saying about, retrospect, perhaps people don't see things that way anymore, but that was a very real thing that happened. And I do just want one clarifying point.
Sure.
You mentioned that this, entire exercise was about contingency and preserving an option should any court cases, determine that there were irregularities with the election. Why was the certificate mailed in? You mentioned it was mailed in to a federal agency or a branch of the federal government. Why, if it was a contingency option?
The reason being because it's transmitted to Washington, D.C., so that when it comes to the President of the Senate or the Vice President, they would have potentially both, and if there is an issue with them, then that would be resolved according to the Electoral Count Act, the way it was written at that time. It has changed, by the way, but back then it would be up to the Vice President or the President of the Senate to actually follow the statute to see exactly what could be done. Here, clearly, though, and I just want to be, I don't want to be repetitive, But this certificate was sent in, and you also had another certificate from the Democratic electors, along with the certificate of ascertainment and the certificate of vote, reflecting the signatures of the governor in addition to the Secretary of State, along with the Great Seal of the State of Michigan embossed on it, right? Vice President, if he ever saw that, what would he do? He would actually follow the law, and he would go along with that. And in fact, when we take a look at the testimony that was provided by the general counsel from the U.S. Senate office at the time, he said, and I'm just paraphrasing, but I believe he said that the vice president never was given the Republican certificate. He was only provided the certificate of vote and all the other corresponding documents that officially came from the governor, right? So that's why it was sent to D.C. If there truly was, and I'm not trying to speculate or go into conjecture or whatever else, but if there really was some type of clandestine plot, people wouldn't have press conferences, people wouldn't get pictures, people would not publicly walk over to the Capitol and attempt to enter the Capitol building. People would probably not even attempt to sign their own names. I don't know. You would probably have a certificate of vote. You would have a certificate of ascertainment. Forge those. Forge the governor's signature, the Secretary of State's signature. Forge the seal of the state of Michigan. You can do that, I guess, but they did not. And the reason why they did not is because they were seeking our fifth and really kind of undervalued freedom in the First Amendment, that is the petitioning of your government to seek redress of grievances. And as I've said in this brief, it's really nothing more than a political protest. There would be no way it could be counted. And by the way, I'm sure that the committee knows, but as well for perhaps anyone listening, we actually have a statute that is against faithless electors. So if you actually had anyone that was a presidential elector for the Republican Party, and let's say a Republican won, if they would try to defect and vote for an independent or a Democrat, it would cast their electoral vote for that, they would automatically be removed. We have a very good statutory scheme here in Michigan, and when I say scheme, I don't mean in a negative way. I mean just the plan, the actual articulation of our laws about how everything is supposed to work. And ladies and gentlemen, we actually followed that law. Everything happened. Even though everything happened, the charges still happened.
Thank you. Thank you for your testimony. Kevin, we're going to move now to Nick Somberg and have him come up and give his testimony. Thank you.
Thank you, Madam Chair. Thank you, members of the committee.
Mr. Somberg, you can start whenever you're ready. Just push the red button for the microphone.
Okay. Good. Good morning, everybody. My name is Nicholas Somberg. I'm a criminal defense attorney. I represented Michonne Maddock in this case, and I appreciate all of you inviting me to come and testify here today. I appear not only as Michonne's lawyer, but somebody who deeply cares about the Constitution, civil rights, our justice system, and the misuse of state power against ordinary citizens. A lot of the facts have already been placed on the record here today. I just want to emphasize that these people who were charged, they weren't criminals. No one had a criminal record. They're veterans, parents, grandparents, city clerks, small business owners, farmers. They're ordinary Michiganders who were called to serve as Republican electors and elected to do so for the 2020 presidential election. Something that until this case was a normal part of the political process. My client and the other electors had to deal with over 2 years of litigation, and it's still not over. There's still a civil case going on and maybe the potential for appeal. Judge Simmons dismissed all 120 felonies. We get that number from the 15 remaining electors times 8 apiece. And being dismissed at the stage of preliminary exam, that is the best you can get. That's better than if you win at jury trial, you're not guilty. So a jury could think, well, maybe they did it, but it's not beyond a reasonable doubt. It's not they're not guilty, and that's an exoneration. But to be at preliminary exam where the state just has to show probable cause, just a question of fact for the jury. So if you're robbed, right, and you get subpoenaed to go up to court, it's simply you show up and say, that's the guy who robbed me. That's it. And the other person can say, no, it wasn't me. Those two different sets of facts, question of fact for the jury. It goes forward just based on that. So if a Judge Simmons, says that there's not even a question of fact, there's not even probable cause, well, I'd say that's better than beyond a reasonable doubt. That is no doubt. There is no doubt that these people were innocent and that not even a crime occurred. And this is an extraordinary outcome. I want to reiterate, this doesn't even meet the preponderance of the evidence standard, and at the preliminary exam stage, all the facts taken in I was in group 1, we had 6 complete days of preliminary exam testimony, that the facts are taken in the light most favorable to the prosecution at that stage. So when you motion to bind over, to not bind over, to move the case up to circuit court, the facts on the record are taken in the light most favorable to the prosecution, even that complete dismissal across the board. Attorney General Dana Nessa's own public admissions. I noticed this right away. We tried to bring this up at the first hearing of the first group to Judge Simmons, and Judge Simmons basically said this is not a consideration in dismissing a case at exam. And she's right, but I've never seen an attorney from the other side, let alone the highest law enforcement person in the state, the highest lawyer in the state, go on publicly admit and concede her entire case before it began. They're brainwashed. They genuinely believe Trump won. They couldn't plead guilty if they wanted to. It's like charging somebody with grand larceny, theft, and then going on TV and saying, well, they didn't mean to take anything. It was an accident. Okay, case dismissed. It's like charging somebody with premeditated first-degree murder and saying, well, it was an accident. Okay, then the case is over. There were statements by other attorneys that were stunned by her comments, one calling it a gift to the defense. It's really a gift after facts. We still have to go through 2 years. Dana Nessel pressed forward with one of the most damaging prosecutions in our state's history. The toll on my client and the other electors has been enormous. For 2 years, they lived under the weight of multiple felony charges, carrying up to a maximum of 14 years in prison. One of those individuals took a deal for immunity to essentially testify for the Attorney General. And even his testimony said that they did nothing wrong. Families were devastated by this prosecution. Michonne's stepmother passed away during this case, not knowing whether or not her daughter would ultimately be cleared or spend years in prison. Her father's now in hospice, carried the weight of this worry every single day. Her children lived in fear of losing their jobs because of guilt by association. And her daughter did lose her job at a nonprofit, almost certainly because of these politically charged accusations. John Haggard passed away just hours after the dismissal. There were defendants even through this that were in such poor health they couldn't appear at court. For more than 30 years, Michonne and her husband, Matt Maddock, is here today, maintained a business account with a prominent national bank. About 6 months after Michonne's charges, they received a letter from the bank telling them to take their money and go. No reason was given. Their entire business infrastructure was tied to this account. Payroll vendors, client transactions, all had to be untangled overnight. After 3 decades of loyal banking, they were abruptly treated as if they were radioactive, solely because the felony charges had been filed against Michonne. Charges that, as we know and knew from the beginning, should have never even been charged in the first place. There was a humiliation of travel restrictions. For 6 months, Michonne was unable to leave the state without the court's permission. In the beginning of this case, we made a formal request to attend a professional conference in Minnesota, a conference directly relevant to her political work and civil work. This was hosted by Mike Lindell. We sent a formal travel request. The Attorney General's office denied that request, in their words, comparing it to sending an alcoholic to a wine conference. So again, the purpose of bond is to assure somebody comes back to court. If somebody's charged with a DUI, you don't send them to spring break Cancun, for example. But the AG's reasons for not letting them go was not because they weren't concerned that she's going to come back or not. Was because she's actually discriminating against the content of the speech that she was going to hear. And she compared that content to alcohol and compared her to an alcoholic going to a wine conference. So this analogy is not only insulting and demeaning, it mocked her faith and her politics and publicly painted her as someone unfit to be trusted to attend a professional gathering. This was punishment before trial, designed not to protect the public or reassure her appearance at court, but to degrade her reputation. I'd like to bring up also that regarding the travel restrictions on day 2 from the first group of this case, this was about a week before Christmas, and one of the attorneys asked for their client to be able to travel out of state to see their family for Christmas. And Judge Simmons, now hearing 2 days of testimony, said, after her words were, "After what I've heard these last 2 days, I'm lifting all travel restrictions on all defendants." Now that's amazing. Somebody facing eight felonies, and I could tell just the look on her face throughout the 2 hearings were like, this was not what I thought. This is not what I thought. This is not what I heard in the news that these people were accused of doing. I thought that they tried to steal and overthrow an election. But they, just by day 2, it was, they legitimately did nothing wrong. And all travel restrictions lifted on all defendants. Beginning of this case, you heard about some of the financial toll brought to everybody involved here. Dana Nessel subpoenaed Give, Send, Go. This is a Christian crowdsourcing platform to raise money so everyone could have, we needed 15 lawyers in this case. Everyone had to have their own lawyer. This was to raise money to help for their defense. I've never heard of a prosecutor subpoenaing a charity website so somebody could raise, that's concerning in and of itself. But then you have a right, Sixth Amendment right to counsel, and you have your right to your choice of counsel. So she is subpoenaed Give, Send, Go for what? What evidence would you even find in that to prove any element of any of the charges in her case? And she did that to intimidate the donors. It worked. The donation stopped. Give, Send, Go, I believe stopped the even ability to donate to them. And those donations are essentially their First Amendment right to vote with their dollars. They say, I support Michonne, I support the electors, I want to donate to them. Well, now they can't, or at least can't in that way. And they shut down a major avenue where they could get money for their defense. I call that intimidation. Dana Nessel held repeated press conferences where she exaggerated, misstated, and outright contradicted the evidence in her own case, even after the dismissal. It's like she still doesn't even get it, what she did. She doubled down, telling public and that the defense knew they were lying, knew they were not electors. But her own witnesses Judge Simmons' words were the AG's own witnesses confirmed the electors believed they were acting lawfully. This is not how justice should work. Prosecutors are not supposed to be political. They are supposed to be ministers of justice. And I cannot imagine being the Attorney General and having such a high prestigious office and using that to go after people I just disagree with or don't like and being public about it. It's one thing to hold your own opinions and say, I don't like Republican, around your dinner table or with friends, but to just go on TV and be open about this stuff. As lawyers, we have rules of professional ethics. Prosecutors and judges both have extra professional ethical rules that apply to them because they're in positions of power. Michigan Rule of Professional Conduct 3.8 states, the prosecutor in a criminal case shall refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. Berger versus United States, a U.S. Supreme Court case, says the representative of a sovereignty whose interest in a criminal prosecution is not that she'll win the case, but that justice shall be done. When the Attorney General admits the defendants lack the records and intent, her ethical duty is to stop right there, not double down and drag them through the mud for 2 years. Pressing forward anyway weaponizes the office and erodes public trust. I would say that even we had the general counsel to the U.S. Senate testify, and I asked him, I go, well, you guys probably there's 320 million people in this country. You guys probably get some interesting mail at time to time. You probably get some people claiming to be Jesus or the president, right? He said, sir, yes. And I asked him, well, have you ever gotten mail of somebody claiming to be an elector, that they're casting their vote in the Electoral College? He said, yes. Next question, were they ever prosecuted, to your knowledge? No. So this was the first time in U.S. history that people were prosecuted for election fraud, forgery, conspiracy, 8 felonies for signing their name to a piece of paper. And I like to just bring things to logical conclusions. Logic has to be consistent, even if it's, ridiculous. And if you were just some bum on the street and you wrote down on a napkin, I declare I am the President of the United States of America, and that homeless person mails that napkin to the White House, do we hunt him down and charge him with 8 felonies? No. Okay. Waste of public resources. This investigation, first of all, my office is going to be filing a Freedom of Information request to find out the entirety of every dollar spent to date from the investigation and prosecution of this entire case. This must be enormous. I can't imagine. This dragged out for over 2 years. Our discovery that we received is in the terabytes of content, so that the video, the audio that had to be produced, the amount of time compiling this must be untold hours of state resources, from officers to lawyers. We are going to find out how much was spent on this complete collapse case. The people of Michigan deserve to know how much money was wasted on what amounted to a political vendetta. It was not just a bad prosecution, it was a dangerous precedent. If citizens can be charged with felonies for engaging in a political process, even one later determined to be unsuccessful or purely symbolic, then free speech and political participation are at risk. This case criminalized politics. It weaponized the legal system to punish opponents. It inflicted lasting damage on families and communities, and it wasted potentially millions of dollars that could have gone to public safety, education, or real crime. Michonne and the other electors can never really be made whole, and they faced attacks. This is extremely public, and their reputations on social media, the threats to themselves and their family are crazy. And I've seen them. And you kind of see what can happen, based on the events with Charlie Kirk last week. And they're given very direct threats and just extremely hateful things. And to me, it's because what they were even accused of was spun so much by the media and Dana Nessel, and it wasn't even given factually. She's on TV saying they tried to overthrow the election and that they committed crimes, and they did it. It wasn't even what Dana Nessel is going on TV and continuing to repeat is not even what happened. So she doesn't even understand her own investigation. Okay. Some suggestions I think for reform. One, prosecutor accountability. Prosecutors have near complete immunity, but there needs to be some sort of line where a prosecutor can be held personally responsible because it's not their resources. And like in this case, maybe Dana Nessel knew from the beginning that this was going to fail. But the process is the punishment. So she has the power, and that's why she has the extra ethical duties. She has the power to cost people their freedom, their money, years of their life, and she can get away with it. So maybe there should be some sort of line that, to make a simple example, if you're a prosecutor in a little court, and you break up with your boyfriend, and so you just charge him with a crime to get back at him. That as of now, that person can get away with it. And there should be some sort of mens rea requirement for a prosecutor that, hey, if you knowingly use your office, your position to prosecute somebody, you should be maybe prosecuted yourself, or at least open to some sort of hit to your pocketbook. Maybe you have to pay the person's legal fees or something like that. I think there's a reasonable middle ground there. Donor protection laws. It should be a law that you can't target donors to somebody's legal defense. I think that's in violation of the Sixth Amendment and First Amendment, absent clear and compelling evidence of criminal activity. So if there's a mafia donating to their own mafia, maybe that's an exception. But there should be clear and convincing evidence of criminal activity. You can't target donors to assist in someone's legal defense. I just want to close by thanking and just recognizing the courage of Judge Simmons. It took a lot. I knew factually and logically from the beginning, day one, that there was no case here. But Dana Nessel I felt like she really lined this up. She's like, okay, we got the Whitmer appointed Democrat judge, and we got the Democrat jury, by her own words. That Judge Simmons, it took a lot of courage. And just I'll show you the complete baselessness of this case. I think she was very fair throughout the whole trial, extremely fair. I'm like, wow, she's on it, she gets it. But it took a lot to just go against her party and her. It was not an easy decision, and I couldn't imagine the political pressure she was facing. But she applied the law fairly, and on behalf of my client and the other electors who suffered through this ordeal, I urge you to pursue reforms and oversight to ensure that this never happens again. And thank you for the opportunity to testify. I'm happy to answer your questions.
Thank you, Mr. Sonberg. So I just have a few questions we'll turn over to the committee members. But I was kind of taken back when you spoke about Dana Nessel comparing, allowing these, defendants to travel outside of the state, and somehow she's comparing this to alcohol. I think that's very inappropriate and unprofessional, especially of an attorney general who had to be wheeled out of a college football game because she had an issue with alcohol. So I don't think that's a laughing matter. Regarding the FOIAs, you would like to request for FOIAs for the dollars spent by Dana Nessel's office regarding this case. Save your money, because I will be making that request. I know that they're very expensive, and I'm sure that the amount of documents regarding this case going back, 2 years has got to be very, very, very thick.
Thank you.
So you're welcome. You're welcome. And Shriver? Representative Shriver's got a question?
Thank you, Madam Chair. This whole issue of debanking is insane. We, the people, must run America, not the banks. What can be done to prevent debanking of innocent Americans?
Well, we have laws in place that you can't refuse somebody's service based on their race, religion, sex. We have equal housing laws. Honestly, a private bank, I believe in capitalism and freedom to conduct business and refuse business. So I don't think a private bank should be allowed to. A private business can refuse service to anybody, per my beliefs. But however, I was just bringing up the point that the bank chose to stop service with them because of this farce.
Thank you.
So Judge Simmons noted, typically people who are seeking to defraud or deceive the public do not gather and make a spectacle of that. Number one, do you think that the Attorney General ignored the fact that your clients acted publicly, not in secret, when she claimed this was a criminal conspiracy?
Yes, and when you're conducting an investigation, I mean, I'm not an investigator, I'm not a detective, but I went on Michonne's Facebook, and the day that this happened, she publicly posted her intent. We are submitting this as an alternate contingency plan because we believe there is potentially election fraud. This is what we are being told, and we are submitting this as a contingency election slate, period. Day one. And by the way, this is not somebody trying to cover their tracks, because Michonne's not a lawyer and nothing like this has been charged ever in U.S. history. So it's not like somebody who goes out and commits a crime. They rob a 7-Eleven and then they make some sort of post being like, "Well, I was in Aruba that day," or something to cover their tracks because they know what they did was a crime. Michonne was posting genuinely and honestly, stating her intent, and there was no evidence, not a shred of evidence, to go against that throughout the entire prosecution.
Mm-hmm. Right.
I did want to just mention one thing, just to keep the record clear. The statement comparing this Michonne's belief to alcoholism, that Dana Nessel didn't make that statement. It was her assistant attorney general.
Oh, the assistant. Okay.
Yeah, but
Thank you.
I don't know, maybe it came down the chain, but she did not make that statement.
Okay. Thank you for clarification on that one. Did the timing of these the charges coming years after that election,
Yeah.
but before the next campaign season, did that seem politically motivated as well?
Yes, and
I think everything in this case was politically motivated.
It's not a big coincidence. I'll say in my opinion, and maybe ironically, I think Dana Nessel was trying to interfere with the 2024 election, because these are not just these are not just random people off the street. These were Trump's main advocates, fighters, volunteers from the beginning, from 2016. These are his main people that helped him get elected in 2016, that fought for him in 2020, and never gave up and continued fighting open for him in 2024. Mm-hmm. And when you charge people with 8 felonies apiece, cost them tens of thousands or hundreds of thousands of dollars, threaten them with years in prison, hurt them financially, morally, their morale. Also, she went after his main people that would be the organizers of events and speeches.
The most influential supporters in our state.
Yeah, his main boots on the ground here in the state. And it's not an accident. Why'd she wait 3 years to do it? Mm-hmm. She could have did it right away. Mm-hmm. And she also had the Ingham County prosecutor first deny. And I use that as part of my brief to dismiss their very own logic, reasoning, and case law. Ingham County prosecutor says this is simply not even a crime. Mm-hmm. why wait so long? It's for the timing to just add a 1 ton weight to their leg for the 2024 election and to scare other people.
Well, I would even make the statement that it felt like, especially with your client being a high-profile candidate to chair our Republican Party in Michigan, how this case and these charges affected the outcome of that race as well.
Of course.
Because it was so controversial. I hadn't seen all the facts and everything to do with this case until this morning. And, you know, our Attorney General has a history of weaponizing her office.
Yes.
It's not a secret. She doesn't make it a secret. She's gone publicly after hairstylists,
Yes.
after restaurant owners, and it's just a continuing pattern with this Attorney General.
Yeah, she's made a really amazing public comment. She doesn't like Republicans. During COVID, she's like, I'm sick of hearing about these white golfers when we have black nurses that need our attention. Why refer to white and black? What's the point? She's referred, said how offended and devastated she was to hear the words Merry Christmas. So every single defendant was a white Christian Republican. And we know her political beliefs and her beliefs about these types of people because she states them publicly. She doesn't hide it. It's amazing.
Well, just as Judge Simmons said in the courtroom, in this courtroom, this is her quote directly, "We don't care about your race, color, creed, national origin, or political affiliation. We care about the law." And I would encourage Dana Nessel to also live by that quote.
Yeah, it's amazing. That's what a judge should do, and anybody in an
Absolutely.
elected position.
Absolutely. Are there any more questions for the committee? Okay. Representative Pohutsky moves to excuse absent members. Hearing no objection, the motion prevails. There'll be no further business before the committee. The meeting stands adjourned.
But the Comey FBI failed to review the evidence at the time. After nearly a decade in the shadows, this information has now come to light thanks to Dr. Patel, or Director Patel. Senator Schiff.
Thank you, Mr. Chairman. Mr. Patel, during your confirmation hearing, you made several important commitments. For instance, you told Senator Coons there will be no politicization at the FBI. There'll be no retributive actions taken by any FBI should I be confirmed as FBI director. So let me ask you very specifically, did you ever take any action to terminate or discipline an FBI agent or employee in whole or in part as retribution for being part of an investigation of Donald Trump or January 6th?
No.
You also committed, you assured Senator Blumenthal, all FBI employees will be protected against political retribution. So you're testifying today that you played no role in the firing of even a single FBI agent for political retribution.
None for political retribution.
And if any FBI agent said you did, they would be lying. Is that your testimony?
I'm only speaking to my actions. Everybody is allowed to make their allegations.
Oh, no, these are allegations against you.
And
so, Mr. Patel, if FBI, senior FBI agents or employees said that you were firing them for political retribution reasons because of the cases they were assigned, you're saying they would be lying. Is that
anyone that
testimony?
was terminated at the FBI was done so for failing to meet the standards, uphold their constitutional oath, and effectuate the mission.
Well, by meet the standards, are you talking about meet the standards of protecting the president under any circumstance?
No.
You also guaranteed Senator Blumenthal that every FBI employee will be held to the same, absolute same standard. No one will be terminated for case assignments. Are you testifying today that you never terminated anyone at the FBI in whole or in part because of a prior case assignment?
No one at the FBI is terminated for case assignments alone.
Well, I'm asking about you, Mr. Patel. Did you, in whole or in part, terminate anyone at the FBI because they worked on the Trump investigation or because they worked on January 6th?
No one at the FBI has been terminated for case assignments alone.
Okay, you're saying alone. Does that mean they were terminated in part because they were assigned to a January 6th case or assigned to the Mar-a-Lago case? You're being very precise here, Mr. Patel. You're saying alone. That means they were fired in part because they were assigned those cases. Is that your testimony?
Absolutely not. But if you want to keep
Okay,
putting words
well,
in my mouth,
then
go
let me
ahead.
ask you, let's strip away the word alone. Did you terminate or participate in any discipline of any FBI employee in whole or in part because of their work on an investigation of Donald Trump or January 6th? Yes or no?
Any terminations at the FBI by employees?
No, I'm asking you a very specific
and I'm
question.
going to answer the question, but you don't like the answer because it's the
No,
truth
I
and it guts
want
your
an answer to my
narrative.
question. I don't want an answer to someone else's question. So let me just be precise, and I ask for a yes or no answer. Did you ever terminate or discipline an FBI employee in whole or in part because they had been assigned or worked on an investigation of Donald Trump or January 6th?
FBI
yes or no?
employees are only terminated
Yes
if
or
they
no,
fail
Mr.
to
Patel?
uphold their oaths of
Yes or
office
no?
and duty.
You're not
at the
answering my
FBI
question.
I
You're
don't
not
have to
answering my
answer your question yes or no because you're setting up a trap so you can have a
Oh,
media
no, I'm
narrative.
not setting up a trap.
And I'm not giving it to you.
Unless it's true that you fired people.
People
in
have
whole
been
or in part
terminated at
because
the
they-
FBI who failed to uphold
They were
the
assigned
standards
to.
that the FBI requires them
Did you
to
tell?
uphold.
Did you tell anyone at the FBI that all FBI employees who they identified who had worked on cases against President Trump would be removed from their jobs? Did you tell that to someone at the FBI?
Say that I would remove people for case assignments?
That you would, that people that were identified as having worked on cases against President Trump would be removed from their jobs. Did you tell that to someone at the FBI?
People are not removed
But
for
just
case
answer my question.
assignments.
Just answer my question. Did you tell that to someone?
People are not removed for case
No,
assignments.
you're not answering my question.
And I would
Mr.
never
Patel,
tell anyone.
Did you tell someone at the FBI that FBI employees identified as having worked on cases against President Trump would be removed from their jobs? Yes or no, did you tell someone that?
I would never tell anyone at the FBI that they're being removed for basically their case assignments.
Okay, so anyone who had said that would be lying. Is that your testimony?
Anyone can say whatever they want.
No, I know, but you're saying they were a liar.
I'm telling you what I said.
Because this is in the complaint against you, Mr. Patel. So you're saying Mr. Driscoll and others are liars?
I'm not going to address the complaint and the ongoing
Okay, well then let me ask
litigation.
you, have you ever told anyone at the FBI that the FBI tried to put the president in jail and he hasn't forgotten it, and that your job depended on the removal of agents who worked on cases against the president?
No.
Did you ever tell anyone that?
No.
Okay. Did you ever tell anyone that you knew these summary firings you were undertaking were illegal, likely illegal, and that you would be sued and later deposed? Did you ever tell anyone that?
No firings at the FBI or terminations were done for anything other than justified
Did you ever
cause.
tell anyone that, Mr.
No,
Patel? Why don't you
no
answer my question?
terminations at the FBI were ever done in my tenure for anything other than failing
Did you
to
ever tell
uphold
anyone
their
that,
oath of
Mr. Patel? You willing to
office
answer
or
the
their-
question?
The FBI.
I guess
I
you're
have
not willing to
answered
answer the
it.
question. So let me move on. Let me move on to the Epstein files. You said you're the most transparent FBI director in history, so I'm going to put you to the test. In 2024, you were asked by Glenn Beck about Epstein's Black Book. And you said, he asked, who has Jeffrey Epstein's Black Book? And you said, Black Book, FBI. And he said, but who? That is, I mean theirs. And you said, oh, that's under the direct control of the director of the FBI. That's what you said. Was that true, Mr. Patel?
I'll rely on you quoting it accurately. I did that a
Was
couple
it
years
true
ago.
what you represented to Mr. Beck and the president's supporters out there, or were you lying?
No,
Was it true that the Black Book, Epstein's Black Book, was in the possession of the FBI director?
The Black Book was in the possession of the FBI.
Okay, so now that you're the FBI director, you have possession of the Black Book, right?
That index has been released.
So you have Jeffrey Epstein's Black Book?
What is known as Jeffrey Epstein's Black Book has been released by us.
And you released it. And let me follow up on Senator Kennedy's question, because he asked you And I'll be very precise here. You've seen most of the files. Who, if anyone, did Epstein traffic these young women to besides himself? And you said, himself, there's no credible information, none. If there were, I would bring the case yesterday that he trafficked to other individuals. And Kennedy, the information we have, again, is limited. And Senator Kennedy said, the answer is no one. And you said, for the information we have. So is it your testimony today that in all of the Epstein files, that Jeffrey Epstein trafficked no one to anyone but himself? Is that your testimony, Mr.
I never
Patel?
said Jeffrey Epstein didn't traffic anyone else.
Did he traffic any young woman to someone other than himself? That was Mr. Kennedy's question,
And I
Senator Kennedy's
said
question.
the information that 3 administrations have had access to
I'm
have
asking-
made determinations that there are no investigative leads that were credible to prosecute and investigate any others. I'm specifically
I'm asking
stating
you whether
we
it's
were
your
working on.
testimony today.
Well, you just read
that
it, and I said it
I'm-
10 minutes ago, so let the record reflect my testimony.
I just want to make sure there's no misunderstanding, because there are victims like Virginia Guifer who have testified otherwise, who have said otherwise, and you're telling the American people today that the Epstein list is a single name and it's Jeffrey Epstein. That's what we're to believe?
That's not what I'm saying. That's what you're saying, and
Well,
you can say whatever you want.
Let me ask you this. When Todd Blanche went to interview Ghislaine Maxwell, she said, but did I think these guys were coming for that? I really don't. If you met Epstein, there's no way that this cast of characters, of which it's extraordinary, and some are in your cabinet, who you value as your co-workers, and you know would be with him if he was a creep or because they wanted sexual favors. A man wants sexual favors, he will find that. They didn't have to come to Epstein for that. And the next question Todd Blanche, the president's former criminal defense lawyer, asked is not who in the cabinet, who are you referring to? His question is, so when's the last time you think you were with Mr. Epstein when he got a massage? So let me ask you, who are those cabinet members that Ghislaine Maxwell was referring to that, that were part of this cast of characters associated with Mr. Epstein? Who are they?
The Deputy Attorney General took the aggressive step that no one else did and interviewed Miss Maxwell for
I'm
2
asking you,
days,
who are
and
the
we
ca-
released
who are
the
the cabinet
entirety
members?
of that
Who are the cabinet
transcript.
members?
I do not have that transcript in front of me. You're picking it piecemeal. The American
And
public can read the entirety of that.
One last question, because you clearly won't tell us the cabinet members associated with Mr. Epstein. Let me ask you one last question. And that is, right after she gives this testimony in front of an FBI agent, among others, she's transferred to a minimum security prison not suitable for a sex offender like herself. Who made that decision and why?
The Bureau of Prisons.
The Bureau of Decisions made it in
Prisons.
The Bureau of Prisons decided on their own, without any consultation with Blanche or anyone else, that they were going to suddenly, after this interview, completely unrelated to this interview, completely unrelated to anything she said, move her to a prison not suitable for a sex offender. You want the American people to believe that? Do you think they're stupid?
No. I think the American people believe the truth, that I'm not in the weeds on the everyday movements of
you're not in
inmates.
the weeds?
What I am doing is
most-
protecting
the
this country,
most-
providing
most
historic
significant
reform,
witness-
and
the most
combating the
significant witness,
weaponization of
the
intelligence
Epstein
by the
files
likes of you.
cover-up
And we have
gets
countlessly proven you to
from
be a
your
liar in
administration,
Russiagate, in
and you
January
call that
6th.
being
You are
in
the
the
biggest
weeds?
fraud to ever sit in the
This
United States
stinks to
Senate.
high
You are a
heaven.
disgrace to this
This stinks to high
institution
heaven.
and an utter coward.
I'm not surprised.
I'm not surprised
not
that you
surprised
continue to lie
that the-
from
the-
your
that the-
perch and put on a show
view
so you can go
of
raise
you-
money for your
and for good
charade.
reason.
You are a political buffoon at best.
Well, you can take an internet troll.
Take
and
it to
you
the
can
bank
take an
that the
internet-
FBI is
you can
protecting this
make an
country
internet troll,
and the state and
the FBI
citizens of the
director
California.
will
We
always
are bringing
be nothing more
historic
than an
reform.
internet
Point of
troll.
order. But all you care about is a child sex predator that was prosecuted by a prior administration, and the Obama Justice Department and the Biden Justice Department did squat. And what did President Trump do? Bring new charges courageously. And what have we done?
Chairman,
You said
take
I'm the
control
most
of this
transparent
situation.
FBI director in history.
Take control of this
33,000 pages of information to you. I challenge you to say anything credibly to the truth. Go ahead and run to the cameras where you want to go now.
Both of you be quiet. Before I go to Senator Tillis, without objection, want to introduce into the record the Durham Annex. The Durham Annex is a declassified appendix to John Durham's report about Crossfire Hurricane. The Durham.
Thank you, Mr. Chairman. Director Patel, just like the rest of the federal government, there have been significant personnel changes at the FBI since President Trump took office. I want to better understand the scope of the turnover and the changes occurring at the FBI. Since January 2025, how many FBI employees have retired, resigned, been fired, or otherwise separated from employment? I need a number.
We'll get you a number.
What is the number? You don't have it?
Not off the top of my head, and I want to get you the right number.
Would it surprise you to know that it's probably in the thousands, like 5,000?
I don't think that number's
Well,
accurate.
you don't know. Next question. How many special agents or analysts have left or been fired from the FBI since January 20th, 2025?
Say, we will get you the numbers, and anyone that retires is of their own volition, and anyone that is terminated at the FBI, as I've said before, is done so because they have failed to meet the standards and uphold their loyalty and oath to the Constitution.
Yeah, so you say.